I'm Mike Stubbs, here to present on how to protect your idea. Sorry, I'm just accepting the thing there.
Yeah, awesome. Thank you.
Hi, I'm Chris. I am the owner of Great Tech Solutions. We are a streaming company and 3D printing based company here in Peoria, Illinois.
Hello, I'm Elijah Stubbs, student at Bradley University, here for Professor Michael's presentation.
Awesome.
My name is Eric Sampson. I'm the director of the Illinois Small Business Development Center at Bradley University, and I'm happy to be here. I work with Mike. I see a lot of familiar faces here, so welcome everybody.
And I'm Nate Dominigini, director of G-Beta Distillery Labs, same thing. Happy to be here. See a lot of faces I know here, of course, and everybody's been a huge support, so thank you.
I'm John Ingalls, co-owner of Smiley Graphics Studio, and my wife and I do web development and eco-friendly package design.
My name is Andrew Ngui, Director of Innovation and Startups at the Greater Peoria Economic Development Council. We're so pleased to have you here tonight, and I'm going to hand it over to Mike. Okay, Mike.
All right, thank you, Andrew. A little bit more about me for the people that don't know, and I base this kind of on different icons of the different areas. So usually it's a quiz, but I'll walk through it now for save some time and get into a little more time of the other more pressing things of the presentation. So originally from Peoria, went to Champaign, University of Illinois, got a master's in accounting down there, did a 5-year master's program. After that, I went to Chicago and worked for Deloitte. That's the D with the green circle. Was there for about 5 years in forensics and dispute services, so mainly fraud investigations, anti-fraud compliance, or things that go to litigation related to audits, like audit malpractice cases. From there, I wanted to get into more intellectual property type matters, and so I went to a company called FTI Consulting, which is the blue icon with the white bars down there. I was in their intellectual property practice for a little over 8.5 years. So overall, I was in Chicago for 10 years, which, as you see the Chicago flag there. The last 4 years I was at FTI, I was in Bloomington, Illinois, and that's the strange red icon there. But I took the Amtrak up and back on Tuesdays and Thursdays and worked remotely Monday, Wednesday, and Friday. So we've got Amtrak in there as well. 7 months ago, I've got a couple roles at Bradley University and moved back to Peoria. And so at Bradley, I'm the Director of Technology Commercialization at the Illinois Small Business Development Center at Bradley University and the Director of the Peoria Next Innovation Center. So that's why Peoria Next is down there. I'm also teaching Entrepreneurship 385 this semester, which is technology entrepreneurship. And Elijah, one of my students, is here today, so thanks for coming. So little disclaimers, I'm not providing legal advice or accounting advice, and these are my opinions. So what's the value of an idea? I asked this in class one time, and I just kind of generally, what's people's concept of the value of an idea? Anybody have it?
Value of an idea takes plenty of effort to go ahead and think of something that could potentially work, and once you attach a plan to that, that makes it even more valuable, in my opinion.
That's right. Yeah, I mean, overall, it's about the action on the idea, right? The idea is valuable it is to you internally, but to actually make it monetarily valuable, you've got to have a plan on it and protect it in the right way. So how do you make that idea valuable? You figure out how you can actually make money off of it. That starts with how best to protect that idea, and then from there you can figure out how to commercialize it. So what's the best way to protect an idea? Anybody?
Document it. Write it
Document
down.
it? I think the best way is you don't talk about your idea. If you never tell anybody,
That's right.
nobody ever knows.
That's right.
What's the worst way to monetize your idea?
Don't tell
You don't talk about your idea. It's kind of like Fight Club, but the opposite one of Rule 2. So effectively, that's the conundrum you have here is you got to figure out how you can actually talk about your idea and sell it, but also protect it in a way that nobody steals it and profits off your idea. So steps, I'm going to kind of go through some steps. So the first step would be know what intellectual property is, right? So before going to an attorney, just getting an understanding of what intellectual property is so that when you go in there, you kind of have the 101 basics covered. So the time that you're there kind of covers that way. So intellectual property is a commercially valuable product of human intellect. And so there's the rest of the definition on the screen. This is from the Black Laws Dictionary. A lot of the definitions I have here are from Black Laws Dictionary, which is a dictionary that's usually used in litigation. And so the courts really rely on that from an attorney perspective. And so since it's intellectual property and rights related to that, when it becomes important, it goes to a court, and so it's best to kind of know how it's defined from juries and judges and things. So that's generally IP. The other thing would be to know kind of what types of intellectual property there are, right? And so we'll go through 4 different types of intellectual property. The first one we'll talk about is copyright, which really covers your literary and artistic productions. This is kind of an easy way and a cheaper way to protect a valuable IP, but it really covers music, it covers art, it covers different things in which you've created something, you've actually documented it, and you now can submit it to the Copyright Office and get your copyright. We'll get into more, a little bit about this later. But one thing to note is that it is really the production of an artistic thing. So if you're not recording it, right, if you're just presenting or performing or singing on the street, you can't really copyright that. It has to be then recorded by someone, and then maybe you could copyright that. So there's kind of nuance there. The second type of intellectual property that you should think about from protecting ideas are trademarks, which cover words and phrases and logos and other things related to a brand of what you're doing. So that can be a company name, that can be a product name, that can be a phrase that goes along with identifying the actual seller of the product or service. The next one that we'll talk about is patents. So a patent is just really a legal document that shows that you are the inventor of a specific thing. There's a lot of types of patents. The main ones are utility patents, which are actually a product. I've created this product and this is my patent on the product. A method patent, and we'll get into the differences of these a little bit later, which is really a process or method that you've now created that's novel, that gets you to something that's commercialized. There's plant patents, so you can patent plant breeds. So when you're doing breeding of different plants, you can actually create a new breed of plant that hadn't been created before, and you can get a patent on that. And then design patents are specifically on just the design of something rather than on the actual functionality of the product. But you can actually get a design patent as well as getting trademarks or copyrights on like an artistic design. So there's some nuances there, but design patents are particularly valuable in certain circumstances. The last one is trade secrets. And so you don't file for trade secrets, but it protects confidential information in the way all of the rest of what we talked about does, right? So it's know-how, it's formulas, it's process. But what you have to do there is actually show from a company perspective that you've done something to actually protect that information. And so if you're not actually showing from a legal perspective or an actual action perspective that you're trying to keep that information confidential, then it's hard to say it was a trade secret. So if somebody steals it and uses it, you can't then be like, hey, you stole my trade secret. If you don't treat it like a secret, then it's not treated like a trade secret from a court perspective.
How do you want to do questions?
Anytime. Are they coming up in the chat? Or?
No, I have questions.
Oh, you have questions live? I mean, I can just talk and talk, so people feel free to just chime in if you've got questions, and I'll let you know if we're covering it later.
Okay.
But no, that's perfect.
So coming back to trade secrets, to what extent do you need to demonstrate that you've done sufficient, you have provided sufficient effort to keep it a secret? Like, what are we talking about?
Well, so I think, as you mentioned, sufficient effort. So it's like reasonable effort, right? So are you including in contracts, or employment contracts even, that information that's being received throughout your act of employment needs to be confidential in certain ways? Are you actually saving it to secure devices? Are you reducing the access to those folders to people that need to use the information? When you actually are giving it to third parties, are you doing it under NDAs or confidentiality agreements? Are you using confidential clauses in the contracts that you enter into? including the employment contract. So it's kind of, there's not like a bright line of you need to do these steps. It all comes down to that gray area of like, would a general person believe that this was treated as secret? And there's probably some specific legal phrase that goes with, but that's the general concept of what you try to show. But we'll get into that a little bit later too. So overall, copyrights are creative works, or source code can be copyright sometimes. Trademarks are logos and branding. Patents are devices, methods, designs. And trade secrets are kind of like the secret sauce, customer lists, things that people wouldn't know without working for your business. So stuff that you know because you're operating your business or working for a business that you wouldn't know because of that if you weren't employed there. Those are all trade secrets as long as they're being treated as confidential information. Know why you want IP protection is step 3, right? So we talked about generally intellectual property is this, these are the types of intellectual property, but why do you actually want IP protection of what you're trying to protect? So you can file for a patent, a trademark, or a copyright, as we mentioned earlier. In addition to that, you can actually protect your confidential information or your idea by entering into agreements of NDAs and other confidentiality agreements. Including confidential terms and contracts, including employment contracts. All of that was related to the fact that if you're trying to treat a trade secret as confidential, these are ways in which you can do that. And then policies and procedures inside your company to make sure that those are also treated as trade secrets. So those are the types of protection, and we'll get into kind of some of that here. So from a copyright perspective, there's 4 areas in which you can get rights. And so you can, once you actually have a copyright, you have the right to reproduce the work, transfer the work, perform or display the work, or create derivative works, right? So you actually create additional works off of the original idea. Those are 4 different areas in which you've got different rights within a song or within a graphic work or those sorts of things. So from a music example, separate copyrights for music composition, right? The actual composer can have rights on a specific song, so the lyricist also could have rights. There's sound recordings that would then have their own rights, and then even like lighting design of the lighting engineer could then get a copyright on this specific creative work of this lighting design. And so from a music perspective, the music industry gets complicated quickly. For example, cover songs. So does anybody know why you're allowed to play cover songs at a bar?
You get ASCAP license for not performance, but for replay, right?
Yeah, well, so it depends. And a lot of times the bars have their own licenses for public performances of a catalog of songs. So as long as it falls within one of those catalogs of songs, then you're covered effectively by the bar's license who's hired you to play the songs. So it really depends. What you're talking about from that perspective, you want to include it on a CD or a record that you're putting out or whatever. CDs, nobody buys CDs anymore. But yeah, effectively. So looking at that, right? So you've got different people that have different rights, and a lot of times the artists themselves have already sold their rights, and so it's finding who owns the rights to which artists and where does that go, and that's why it becomes complicated. But in addition, if you think about the music industry, if you're creating a band, right, your actual name of your band is trademarked, and your songs are copyrights, and your logos are copyrights, and what you're selling from a merch perspective is all based on those rights to be able to sell that. And so that's why it becomes important in certain industries. But when you think about different industries, different types of intellectual property protection become more important than others. So for example, in medical devices, copyright doesn't really play into anything. Right? And so there's just different ways in which you've got to think about this from an industry perspective. We're going to do a couple patent challenges today. Oh, yeah.
So, copyright.
Yeah.
In relationship to, say, artwork or a written piece or anything like that. My understanding before was that if you were the creator of it, essentially you, by de facto, own the copyright.
Yes.
But legally standing, where does that push you?
Yeah, so that means that effectively nobody else can copyright it. But if somebody actually steals it and you want to actually sue somebody on that, it's very hard to do it without an officially registered copyright. And so so that's kind of where that plays in. And so if if you're thinking about why do I want IP protection, which is kind of this area, if you're never going to file a lawsuit, then maybe you don't need the protection, right? But at the same time, if somebody steals it and you don't have the protection, then you can't actually have that choice later on down the road to actually do it. But you've got to really weigh the pros and cons of like how expensive is it to file and get the copyright, which is cheaper than other types and forms of intellectual property, because as you mentioned, you are the copyright owner, you submit what your work is, you get a copyright and you pay the filing fee. It doesn't require as much attorney involvement, right, from a strategy perspective. But if you don't follow through with that process, then it's different than trademarks where from a trademark perspective, you can actually sue for trademark infringement for local companies that are infringing, even if you haven't filed for a federal trademark. You can't do that with copyrights. You actually have to have a copyright filed and approved to actually do an action related to copyrights.
Follow-up question. So you need money to be able to file a legal suit.
Yes, sort of, usually.
What do you mean?
So there are companies that will then file on your behalf as long as the damages and probability make sense from them from a financial perspective. And so there are collections of attorneys that work for companies that are patent assertion companies, or they are even, there's started to be some companies that'll do it from a trademark perspective, where you license them or they buy and exclusively license back to you whatever intellectual property that is, and that they will actually file the suit on your behalf, right? Because now they're the owner. And actually, because they're the attorneys, they're doing it pro bono in a sense. They're doing it for free for themselves, but they're not. They're just not paying themselves. And then you would get a cut of whatever the winnings would be that came out based on the agreement that you'd have with them.
So follow-up question to that is, at what point is it worth from a monetary value to file legal action?
Well, so it depends on the case, but you would then talk to different companies that would do that, right? Different law firms that provide those services to see if anybody's interested. You also can do it from there are certain insurance policies that will cover things related to infringement, but it's difficult to get that coverage and expensive. But for example, a patent infringement case, if somebody's infringing on your patent, patents are federal court, and so it usually costs at least $3 million probably to actually get through a trial. And so in order to do that, what does that look like? So you've got to make sure that the sales and damages are substantially high. But filing, the actual act of filing, you can get earlier decisions from judges if it's a very clear case of maybe a preliminary injunction where they can't sell all of a sudden at the beginning of the lawsuit, which costs a lot less. You're just not going to go all the way through the trial and get those damages and come back.
So from a small business perspective, like what are we looking at in terms of money out of pocket for legal action that is actually worthwhile?
Well, so it depends on why you're getting it. So from a legal perspective, there is the assertion if somebody has infringed.
Yeah.
But then there's also the ability to exclude people from the market from a financing perspective, right? So depending on what your small business is, if you're trying to raise funds, more people will see it as a protectable, novel business that has sufficient ability to grow. If you then can show that you do have that patent and you have the right, and it shows that you have that novel idea that's been created that creates the value of the company, that itself can have value outside of trying to assert it against somebody that might infringe.
Right. So it's more like a strategic play more than just suing for.
Right. And there's different ways you can actually get protection from a small business perspective that I get into in the next steps that are more important than filing and spending the money to get the patent in the first place.
One last thing.
Yeah.
I'm sorry.
No, you're good.
With filing copyrights, right?
Yeah.
So filing copyrights, we found that it's cheaper to file for those copyrights on, say, artwork.
Yep.
That hasn't been released to the public yet.
Okay.
So you can do groups of like 30 or 40 or 50 or whatever it is. If it's photography or artwork, you can do it all in one lump for a single filing fee, which is like $30 or $40, something like that. But if you've like posted the artwork on Facebook or you've created a T-shirt with it, now it's individually.
Yep.
So
Yeah, and
I just want to mention that because
yeah, no, that's
we
great.
ran
It's
that
super
for-
helpful for
Yeah.
a lot of people here and
Yeah.
for small businesses. If you look at the filing fee chart from a copyright perspective, there's so many different categories of where things fall into, but a lot of from an intellectual property perspective, that if you do it before it becomes commercial, it's usually cheaper and it gives you more rights than if you do it after you've already started selling it. And we'll talk to that a little bit.
Oh.
That's all right. Oh, I can't open it. 1 minute. I'll bring it open over here. So, 2 seconds here. Here. Let's move this over. Yeah.
It's not. Oh, okay,
It
good.
should be should.
Yeah, it is.
All right. So this is a patent. This is what a patent looks like. I'm going to zoom out a little bit. And so you have the title and the abstract, and you have images, and this is a strange one. And so the question is, what are we actually showing here? What's this end product? Anybody have any idea what that is?
I'm gonna guess it's a player piano, but
That's how the sausage.
I don't know.
I mean, you're the food guy.
Looks like chicken wings.
It looks like chicken wings, doesn't it? This is actually popcorn chicken.
Oh,
This
wow.
is the method of creating popcorn chicken. And so 11 here is a method of making food products. So we'll go back to the slides here. So we'll get, where did I put the guy? This guy, Eugene Gagliardi, is the inventor of the steakums, but is also has a patent on popcorn chicken. And so his job, he's just created a company that all he does is create different cuts of meats to then patent them and then license those to companies that would then sell it, right? Like the Awesome Blossom or Buffalo Wings, or certain things. But his are steakums and popcorn chicken. So that was the patent that he did for popcorn chicken.
You could do this, Andrew.
Yeah.
Yeah, I don't know.
So Andrew, back to kind of small business and what this looks like from a small business perspective and where it might make sense from a cost basis. It's substantially cheaper to get what's called a provisional patent or a provisional patent application. That allows you to basically have dibs of the timing in which you've created that novel idea. You don't have to go through the extensive filing of like a full filing process from a patent perspective. It does have to be specific enough to show that what you are filing a provisional patent on is consistent with what you would file your full patent on. But once you file a provisional patent, you get 12 months until you actually have to file your full patent, right? So it gives you the ability to say it's patent pending. It might actually be 18 months, but it depends on the circumstances. But it gives you the ability to say it's patent pending before you actually then have to file a full patent. And so if you're a small business, you can be like, all right, here's what I created. Here's my provisional patent. I'm going to spend a couple $1,000s to get the provisional patent. Now I can say it's patent pending, and I don't have to worry about it for a year. And then effectively after that year, once that year is coming up, you're like, okay, now that I've done this for a year and I've tried to create a product off of it and commercialize it, do I still want to file a full patent on it, or have I pivoted and gone to something completely different and now I've saved a bunch of money because I didn't actually get the patent on the first thing in the first place, right? The other thing that's great about provisional patents is if you don't actually file a full patent, they never become public, so they just kind of go away. And so you're able to say that you're a patent pending and you have that ability to kind of be in the market as a patent pending company for a year without having to spend the vast amounts of money to actually file a full patent. Any questions on that? Once you actually do file a full patent and it's not approved yet, you're still patent pending, and so it allows you to continue to do that. But if you see stuff that says patent pending, it might actually not be patentable. They've just filed a provisional patent and are just have a placeholder for a year to just try to let people know that they've at least done that step.
So what happens after the year?
Then you have to say it's not patent pending anymore. Or you have to file a patent application, then you're still patent pending, and then you wait until the actual full patent gets approved. But it also gives you the ability to think about the other features and ways in which your product might be novel, or when you add stuff, include it kind of in one patent or in a couple in different ways, and just buys you more time.
So just follow-up question to that too. In terms of when you file as patent pending, does whatever you file become prior, sort of like prior art or prior work in terms of sort of
The literature they look
yeah,
at.
yeah.
I don't think they actually look at when you do the prior art searches, you're mainly looking at patent applications that have been published and actual patents and international patents and international applications, and then even research papers and things. So if they then file a full patent application, then it may become that way. But usually it's not in the prior art that you're going to be able to do yourself, and so it might be in some further diving that the USPTO would do. But they also have to keep it confidential until the publication of that information, and so it's hard for them to then actually be able to use it to say it's prior art.
So that's a good question, I think. What is prior art? Why is it important to examine that? What does that even mean?
We'll get to that. It's one of the steps.
Oh, good.
So back to that popcorn chicken example. So this was the method that was in there. So we talk about method claims that are in patents. And so it was a method of making a food product from the thigh of the bird, this and that and the other thing. So this is the specific method. So if you actually perform this method, even at home, you're effectively infringing the patent, right? You also have what's called generally a utility claim or a systems claim. In this case, it's a product. So it's a food product made in accordance with the method. So we have the method, and then we have the food product made in accordance with the method. And so in the same patent, it's like claim 11 is the method and claim 12 is a food product. Some patents just have methods, some have utility claims, some have both, all that sort of thing. But why would it be important, you think, to have, in this case, a method and a food product claim if you're doing popcorn chicken?
Because you're hoping to sell the finished product.
So if you sell the finished product, which claim are you infringing?
The utility,
Yeah, but not the method.
but not the method.
But who's infringing the method?
Whoever manufactured it.
Right. So in this case, if you actually get the patent on it and it's the business he's trying to do, you can actually license it to suppliers who then have the ability to do the method, but you can then also license it to restaurants who just want to sell a product that looks like this, that they're going to make it themselves. If you buy a product though, so if you are a supplier of popcorn chicken to restaurants that then sell popcorn chicken and you use the method, the restaurant that buys that product can't be infringed by your patent because they've bought it from somebody who's already paid you a royalty. So you can't continue to sue upstream. You can only actually sue at one level. Yeah.
So for example, you talk about popcorn chicken being perhaps a brand, or
Okay.
so would they trademark the name popcorn chicken so that like everybody who sells popcorn chicken has to pay a royalty?
Yeah, that's why they did the Steakums. So the Steakums had a patent on a method and a product, but then also a trademark. So then they could actually trademark the specific product that was done by the method.
So how close does, let's say if somebody just added one more step to
The method.
that list, did they infringe, or because they made a slight pivot or a tweak, then they're okay?
So from a method perspective, you have to perform each of the steps in accordance of what it's listed. So if you do add a step that is substantive before or after, you can, well, not after, before, like within, because it just ends here. So once you've done that, you infringe, right? Once you get to C, you've infringed. If you add a D, it doesn't matter, right? But if you add a step between B and C that's an actual substantive step that actually makes the method differently, then that's what's called a design around, and you don't actually infringe.
Okay.
From a product perspective, if you add more features, it's still infringing, right? As long as the base features are there.
Okay.
So from a method perspective, it's actual steps that have to be performed in a sequence.
Right.
And from a product perspective, it's actually just the composition. If there's more stuff in there, it still probably infringes.
I see.
So let's say if you don't do 12A,
Right.
and then you just do,
Well, if you don't do 12A, then you don't infringe because the product has a bone in it.
yeah, but like, let's say you do 12B, and then you add another before C. Like, what if you did like BAC, would that be infringed?
If you did BAC in 11, it would not be infringed. 12 is really like what the food product looks like after doing that.
Right.
And so if it has the same
Got it.
concepts, then really it probably would still infringe. This is a very strange way in which to do a utility method. Usually they don't say the utility product in accordance with the method before of doing these things. Usually it's like a product. Like from a food product perspective, it's different because it needs to have a method with it. But anyway.
So, I'm just curious because I'm reading this, and it's just from a perspective of
It's bizarre.
yeah. So you have the patent, which is claiming the ownership of all of this, but then you also have trade secrets in there, which are like making it more complicated because the overall process by which this is happening is literally I do this anytime that I want to make any type of like chicken. So how can somebody patent something so generalized?
So in this one, what you have to look at is what is called oh my goodness, how quickly we blank on words. There's a novel aspect of it, right? So what portion is the novel aspect within this that allowed them to have a patent? And so they went back and forth with the patent office probably of like, this is all prior art, it's all known. What has to be novel, so it can't actually be something that would be known by somebody in the industry either. It can't be obvious. It has to be non-obvious and novel. And so they had to prove in here that something was non-obvious. And so if you actually go back to the patent, there's probably a portion of this here, and they show the images to try to make it look better than it actually is. But usually they say that there is a problem. Let's just talk about the images. It can be seen that the present invention combines new and unique method of making a food product from the thigh of a bird and the food product resulting therefrom. It will be recognized by those skilled in the art that the changes could be made to the above described without departing from the broad inventive concepts. For example, all the cutting steps could be done by hand using a knife. It is understood, therefore, that this invention is not limited to particular embodiments, but also includes other ways in which cutting it.
Wow.
Let's see.
That's like so far reaching.
Yeah.
Yeah.
So in here, usually they talk about a problem and how the invention actually solves the problem. The difficulty is that it's not in one specific place. And I've actually had conversations with people. So every patent will pose a problem and a solution to a problem. And that's within this text somewhere. But it doesn't actually have a specific place. It's just somewhere within summary of invention. And one of the things that I've talked to somebody before about is that there actually isn't currently a software product out there, if somebody wants to create a company, that you can actually search patents on problem sets and solutions. So you can't search like, here's my problem, what all patents solve this problem? Or here's my solution, what all problems have been linked to a similar solution. You can actually really only search by like inventor name and date and text and like what types of information are in there and what phrases kind of go where and all that sort of stuff. But so at some point when you read through here, if we had time, we can look at it. But they talk about how the previous problem was that they've never really done it this way and now they can do it this way. But anyway, it's... let's see, a method for making a food product from the thigh of a bird, the thigh having a bone extending generally from the end of the thigh to the other end. The method comprising removing the bone, marinating it for a predetermined amount of time and cutting it, right? Effectively, it just sounds like chicken strip. But somehow they convinced whoever the patent examiner was, right, that this should be approved. So if you go to a actual patent trial on this, right, the defense would be saying what you're saying. It's not novel, it's obvious, and the U.S. government screwed up, right?
Yeah.
And they would tell the jury, have you ever had any issues with the U.S. government at all, like processing a payment or this and that and the other thing? They make mistakes all the time, right? They're overworked, this and that and the other thing. And so part of what the jury would decide is the patent valid? Meaning, should it have been issued in the first place, or was there an error? And those are determining whether it's actually covered by prior art already, or it would be obvious to somebody in the art that this is clearly something that wasn't novel or new. Everybody would just do it this way. What they can show, though, is that before this patent, they weren't selling popcorn chicken. Nobody was actually selling a specific product that was just the thigh without the bone, fried for a predetermined amount of time. And so that's kind of where most of the literature that if you look at what he would have submitted in is like, no, I'm solving a problem. People want this. It's clearly bought now by a bunch of people. And it wasn't obvious, because if it was, people would have done it. There would have been commercial success prior to my patent. There was no commercial success for this product until my patent came out and I released it to the world and everybody loves popcorn chicken. So anyway, that's the back and forth that you would get on those types of
This
things.
leads to another question, which is, how often do patents get, what is the word, like disqualified?
Invalidated? A
Yeah.
lot. So they actually started a separate court called the Patent Trial and Appeals Board. So you can actually file a cheaper case to that specific court that decides whether it should have been a patent in the first place. While you also have a similar litigation in the actual federal court that's really determining the same thing. Except the PTAB decides it from a panel of judges, and the federal court decides it by a jury of your peers. And whoever decides first is usually the one that ends up where that goes. So it's kind of a weird strategy thing as well.
So just because you have a patent, it doesn't mean that you're safe.
Right. A lot of people have lost a lot of money suing people for infringement and then realizing that their patent isn't valid.
There's a whole show called Silicon Valley.
That's right.
I didn't know. I don't think I got that far.
Oh yeah, no, that's a whole plot point.
So, patentable? Yes. What about flavored popcorn? Popcorn chicken? Yes. Flavored popcorn?
They're different, like consistencies, ingredients. Like there's no chicken in popcorn.
Yeah. Is it patentable though?
Oh, is it? Oh.
Any flavor, period.
I would say generally no.
Really?
And the reason for that is that this has a method to it of cutting meat in a certain way and processing meat in a certain way. From a caramel corn or flavored popcorn or gourmet popcorn, most of what you're coming up with isn't novel. If it's honey popcorn, there's probably honey in it, right? If it's sweeter, you probably added more sugar, right? It's really hard to get to a novel way of coming up with a new flavor of popcorn to show that nobody would have come up with this. In addition to that, if somebody actually infringes on it, so that's the patentability side. Even if you got a patent on it, if somebody infringes on it, you'd have to prove that they actually used the same exact method or ingredients that you did, which becomes difficult because they could say, no, I have a little bit more sugar and it's not the same thing or whatever. So a lot of times in this situation, you just want to do trade secrets, right? And that's why you have the secret recipes, right? And you have all of those.
Carrots.
Yep.
Well, what if
they
they?
have so many different brands of microwavable popcorn?
Yes.
Okay.
Yep. And so they might be a little different, but really you're buying the brand and you're buying the trademark, right? So the trademarks and the trade secrets are where that comes in there.
What if you invented a new way to pop the popcorn so that the kernel, you don't bite on the kernel or something? I don't know.
Well, so if there's a new way to pop the popcorn, you could get a patent on the actual product that allows you to do that, or the method in which that occurs. But the actual popcorn itself, right, or the recipe that you've done isn't really patentable, but you would want to keep that as a trade secret and then trademark a great brand name for it, and then people love it and then want to go off of the branding. So that's really where the value from that perspective comes from. Design patents. So a design patent is what it sounds, and so it's on the article of manufacture. Does anybody recognize that?
It's like the iPhones.
Yeah, so that was Apple's figure 3 of their design patent. So they sued Samsung at one point for phones such as this one and others for their design patents. As you see, it's because of the curved outer edges and a somewhat round button on the bottom and a horizontal speaker on the top. This originally was like 400 million in damages, and then it got overturned, and then it was like 500 million damages, and then it got appealed again, and then they settled a bunch of cases at the same time.
Wow.
When you think about design patents, it's the subject matter, it's the design embodied, but it's not actually the product itself, right? So this design patent does not cover that phone, it just covers what the phone looks like. If it was squared edges, it wouldn't infringe this design. They argue that because they've got a rounded rectangle rather than a circle, it's not really the same design, but the jury disagreed with them effectively. They had separate designs in the same court case that actually showed the same design but had 9 icons that came up on the screen automatically. And so there's a lot of Samsung phones that also had 9 icons, like 3 rows of 3 that came up, and so those were accused of infringing that design. The interesting thing on damages from a design patent perspective is it's total profits of infringing devices on the article of manufacture, which is a very strange term that's legalese. But what you have to then decide is what is the article of manufacture. So like this face mask, for example, is the whole thing the article of manufacture, or is it just like if you know, because there's a supplier of the earpieces and there's actually an inner lining that's white, maybe the article of manufacture is just the inner lining or just the earpieces or just the outside rather than the full thing. Because you can buy individual separate articles of manufacture that then go into this product. The jury is then deciding what is the article of manufacture, right? So if this actually infringed a design that was just the outside with this pattern on it, then they would try to remove the profit attributable to the inside and the strings on the outside so that all they were paying for was just the material on the front. But anyway, because of that, the reason for design patents is you're trying to prevent counterfeit goods, right? And so the reason why Congress was like, oh, damages should be all profits is because usually design patents were, people were getting confused on what they were buying because it looked like the actual IP owner's product.
So do you know what happened with this particular case in terms of what they define as the article of manufacture?
So what happened in the first case was that they said that the jury didn't decide whether the entire phone was the article of manufacture, and so then it was remanded, and then they did decide it was, and then they appealed it, and then it got settled before the appeal got settled, and so then nobody really knew how to define that yet. It's still kind of a weird gray area. And that's the interesting part of patent cases is that all the patent law, different cases that come along change it, and so everything's getting refined because products are different now than they were 20 years ago.
So in that particular case, I'm sorry, I'm getting into somewhat of detail.
No, that's right.
But does it set a precedent for other future cases?
It would have. What got returned did. It basically said the jury needs to define what the article of manufacture is.
But which they did, and then they settled out in court.
They settled the appeal, right? So whatever the jury had decided, that didn't become this is the way you do it because it was kind of unsettled. So at the time it was like people still need to decide what it is, and that's what the damages are on, but there's no bright line of like how you actually decide what an article of manufacture is.
Makes sense.
So cases get weird that way. Trade secrets never expire as long as they're secret. So that's a good thing about trade secrets. Patents, you get about 20 years, right? But you must put measures in place to make sure it remains confidential. We talked about that. Back to Eric's question. So the next step is do-it-yourself prior art searches. So prior art is usually kind of related to the patent side of it, and that's most of my background and what I enjoy, and so that's probably why I'm highlighting more of it here in the presentation. But you also want to do it from a trademark perspective. So if you actually are naming a company or naming a brand or naming a product, you should just go to this bottom website and just start doing trademark searches. And I'll show you an example of that, right? So you get an idea of what's already out there. From an actual name of a company perspective, if you want to name your LLC, you can even go to the Illinois state website. You can just do State of Illinois LLC and just search LLC names in the state to be like, oh, it's already taken, I won't be able to get it, right? Before you start going down that route of really loving a name, make sure that it's available, because if it's not, it becomes more difficult. So this bottom one is trademark searches. From a patent perspective, first just Google it, right? A lot of people come in and they have a great idea and they think this is a novel, great idea, but sometimes if you just do a Google search and just get down a little bit and figure out different terms that might not have been used, you can pretty much come up with a lot of the same idea. And so just Google search first, just to make sure it's a novel idea. The next thing is there's two great sites. One is freepatentsonline.com, and I'll bring up kind of an example of what that is at the end of the presentation for people that are interested. And then patents.google.com is Google's patent database. And so there you can actually get information and get PDFs of all the patents and search different things that way. But I'll show you kind of on freepatentsonline.com how you can actually search and do some competitive analysis too. So for example, I've got some pre-populated here where you can, oh, it closed on me. I'll have to bring them back up. Where you can actually search patents that have been filed in Peoria in the last year and a half, for example, right? Or patent applications that have actually been published, right? So after you have a patent, the application itself will be published in 18 months, even if it's not approved yet or not. And so published applications give you an idea of what companies are working on within the last 18 months. So you can see those from a location perspective and an assignee perspective, what company actually owns that and those sorts of things. Trademarks. So trademarks are interesting. They have categories, right? So patents themselves, you have a patent and it covers the patent. Trademarks, they cover a logo or a word on specific categories. So here Pringles is covering potato and vegetable-based snack foods, potato crisps, potato chips, blah, 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 all of these different things. You can't use Pringles, the word, or that image for those categories, but there's a company called Provisional Technologies in Peoria. They're totally fine. Nobody's confusing Pringles with Pringle. But if you were trying to use Pringle without an S for any of these categories, they would say it's confusingly similar. So you wouldn't be able to actually get a trademark on it. They're able to do that here because the actual goods and services are completely different than what the goods and services are of the other trademark.
Does that get sorted by NAICS code?
No, I don't think so. They might be able to do that in different ways. I haven't tried. The trademark site isn't very user friendly. So this is kind of where you do your first round, and then that's where the attorneys that do this all the time are a little better and more efficient. But you can do this yourself for free. And then if you really think, okay, categories available, trademarks available, let's get some help to then file that. That's where they can come in of like, oh, because what'll happen is once you file it, then the USPTO will do their own searches and be like, here's what we found. Like, is it different? Yeah.
So I researched like market structure, like just cryptocurrency, regular currency pairs, stocks, stuff like that.
Mhm.
So as like one of my goals is to become an investment manager.
Mhm.
So I have something called Foundation Forever Investments.
Mhm.
So I do. So what I would need to be worried about trademarks or like LLCs, like what do I need to go ahead and smart?
Yeah, so there's a few different things. So you've got your company name, right? And whatever you want to name that, you want to make sure that you are able to get it from a federal trademark perspective, right? If you want to, and so that will allow you to effectively say that, you know, if somebody's using it, you can have an attorney send a cease and desist order saying, no, it's already got a trademark on it, no matter where they are in the US. Then underneath that, you have your services that you can provide, right? So because you're talking about a service company, and so that itself can have a name. And so like Pringle Technology could have like a brand name of a website, you know, service that they provide, like the All-Star service or whatever, right? They could get a trademark on that service name as well. Some companies decide to name their company the same as their services or product, which gives them less protection in the future and can get confusing. So for example, like Kleenex, right? Everybody knows Kleenex, but if they had a different company name and then they had a product named Kleenex, it would be a little different, I think. But a better example, there's a company called Battery Tender, and they make what are called battery tenders. And so they had a product trademark of battery tenders, but then they were the only company selling battery tenders. Now they want to get into solar products or whatever. Their name of the company is battery tender. And so when your name is the actual product, it's difficult to then diversify and offer other products. And in addition, if you're one of the first products and companies become using that name in a generic way, like Kleenex, then you actually lose your trademark ability of that name because it's become a generic word in society. So from your perspective, you want to think about, is there a trademark available for the name of the company I want to do? And are there certain service names, other names for the services I'd provide if I want to brand that as well, and make sure those are available too? And if those are actually different than your company name, it's probably more beneficial just because it gives you ability to market different areas in different ways.
Okay, just make sure everything is in its own lane.
Yeah.
Okay, cool.
Yeah. And what's interesting about trademarks is that you don't have to file a trademark federally. So these are federal trademarks. So you don't have to file those. And you can still have trademark protection in your general geographic region. And then you could file a trademark later. So here, this says first in use was May 1st, 2015. First in use in commerce is the same date. So effectively, I can't remember when they filed this, but they could have filed it in 2020, and they're just showing that the first time they used it actually in commerce is in 2015. It's different than patent, you just file it later, but the difficulty is you have to show that you used it before the other people that already have it, and you have to challenge a trademark that somebody's filed that's trying to cover what you're doing in order to be able to do that. But if I had a trademark of a company in this area, and then all of a sudden somebody opened across the street using the same name, I can still actually sue them for trademark infringement under common law without a federal trademark, because the people in this region would know about my services from that brand name. So you automatically really get trademark rights once you start selling from a common law perspective, but you can't then sue people broader than that if you don't have a federal trademark.
How do you define when it was first used or first used in commerce? How do you prove that if you file it later?
You don't have to, I don't know if you actually have to give them information. You would definitely have to have it if they were asked for it, but usually it's like, when did you put it on your website, right? When did you first actually make a sale to someone? But nowadays it's like when it's on the website is the first time actually people are aware of it. Or if you announced it at a trade show or that sort of thing. Here's another patent challenge. I'm gonna bring up on this other sheet.
Like patent challenges.
Yeah, we only got two, but these are fun. Anybody know what that thing is? Prevented susceptor structure. Here's some more pictures.
And filter or shower cream.
It does look very shower.
This is the best picture of it here.
Is that like the Hot Pocket?
It is a hot pocket.
Ah,
It's the susceptor around the hot pocket. It's the hot pocket sleeve.
it's a brilliant invention.
This was hundreds of millions of dollars of a damages case
Really?
that was going back and forth, appeals and things. But I believe it's settled, like they usually do. Some of these patents got invalidated and then appealed, and then I think they settled.
Interesting.
But
Did that also include the interior foil lining? Was that part of this patent?
yeah. So it was that's the susceptor part, right?
Susceptor,
So
okay.
we can look at, it's a combination. The utility, let's look at the method of heating or browning or crisping the food item positioned in the microwave heating construct, according to claim 1. The method comprising exposing the food to the exterior side of the first panel of the microwave heating construct, which is that foil that you're talking
Okay,
about.
gotcha.
So is the idea that the foil inside could actually toast the outside without not making the inside too hot, allegedly.
Mm-hmm.
We know how that went, but it still was able to toast it a little better than if
Hot pockets are already a thing, but when you have to describe it like that, it just doesn't sound appetizing.
Yeah. Well, this is just the cover.
Right.
But yes, I totally agree. But related to that, it's an interesting concept, right?
Yeah.
But they sell billions a year, so it becomes Step 5, ask early questions for free. So I'm available at the Illinois SBDC at Bradley University. Things we can talk about: what is the value of the patent? I like this one. What is the value of a patent, right? Like, you now have a patent, what do you do with it? Which is usually a question I ask because people who want a patent usually just want a patent to show that they've invented it, which is intrinsic value. So if it's worth getting the patent, then that's fine. But like from an actual value perspective, it is protecting the novel feature, right? So when you look at it, what you get from a royalty or what you get from an infringement case or whatever will be the value of that novel feature, because they can make the product without the novel feature and not infringe on your patent. But the other thing is that it's also the value of the design around. So we mentioned if you add a step in the method and now you're around it and that step cost you $100, then your patent's worth $100, right? Could be a great thing and it's the best thing in the world, but if you just add a thing for $100, then all of a sudden they're like, oh, okay, I can license this and pay you a bunch of money, or I can spend $100 and get around it. And that's where a lot of value in different industries come in. So that's why you see patents being hugely important in medical settings, because if you actually have a long regulatory process of, FDA approval or this, that, and the other thing, if you make one change, all of a sudden you gotta start all over. And so it's not just like there aren't easy fixes or easy changes in a lot of different industries because you've already started that process, which is kind of a holdup value, but it is what it is. That's kind of how people value it in different ways. So.
Does it really essentially come down to what you value or what you perceive the value to potentially be? Tim, did you put a number on that at all, or how does that?
Yeah. So if you have an infringement case, the value is if you can prove that if you're suing a competitor, and you can prove that they wouldn't have made their sales without you using your patent, then what you've lost are the lost profits of those sales that you would have made.
Okay.
For the products that you didn't sell, so you have to actually show that you have capacity to make those sales. So say they made 1,000, I would have only made 100. I lost profits on 100 that I would have made, but those other 900 were still infringed on. So the damages you get there are the royalties that you would have received had you entered into a license.
Okay.
And so that value is what is the novel feature, what's the design around, what are comparable licenses for comparable technology in the industry at that time. And so you actually look at different patents that cover similar things with similar companies at similar times and say they paid rates of $10 a unit or 6% of revenue or however that was structured. And then you actually project that out on what you think that would be, and then that's the value of the patent plus the lost profits. So those are different ways in which you can value patents in that method. When you're looking at licensing it, it's similar things, right? People are going to do a search of what if people paid for similar licenses under similar circumstances, and that is a good benchmark for what the value of this thing is.
Yeah.
It's also the value of patent is just what somebody will pay you for, right?
Right.
I mean, that's like getting to. That's what the accurate value of the patent is. People can argue one way or the other, but if you have somebody that's going to pay you X for that patent, then that's the value of what that patent is. It's an arm's length transaction. But don't start selling your product. So the US generally allows 1 year of sales prior to filing a patent application. Outside of the US, usually if you've sold it before you file an application, you can't get a patent on it. You actually become your own prior art in a sense. And so if you're thinking about selling a product that's got a novel indication of it, then yeah.
How does that work out with like app development? And would an app development fall into a patent category?
It can be a method or a business method depending on what the app covers. You can actually, so there are different systems that would be app based. Like if you have a actual system method, effectively, it depends on what the app is running on and what it does to see if it falls in a category that's patentable. You can't get a patent on doing something that you would do in a normal day-to-day business and say, I've done it on a computer, because they would say it's not novel. But if there's a new novel way in which you're using some source code, right, and a patent or providing a service, you can usually patent the method or the system that performs the code in a way, or you can copyright the source code itself. There are different patent cases, if we were talking about value of a patent, where you have to apportion down to that patentable feature, that novel feature. So you have to actually remove profits that aren't related to the novel portion. And when it relates to source code, so for example, one of them was on the date picker function of Word. Anyway, basically, well, I had a case, for example, that had a patent on the fact that when you open an email, your phone itself would download maybe a page or two of the attachment, so that when you opened it, you had something you look at, and then you have to scroll further to get more information. But it was only infringed if it was on cellular and not on Wi-Fi, and this, that, and the other thing. One of the ways in which you can argue, one of the ways in which they have allowed in courts to say what portion of the profits are, we've never made this argument because it's ridiculous, was that the portion of the source code that related to the infringing feature versus the rest of the source code of that app. So like basically saying the profit of this component is because the source code, if you look at all of the source code, was only 6 lines of code of 1,000 lines, and so it's 6 divided by 1,000 times the profit, and that's the portion of this feature. I mean, that's ridiculous, but it's allowed in a court perspective because there's math that you can show. But like all of the arguments there, like inefficient coders write longer, so if there's less code, there's less value there. Or why does it have to do with any value of the actual product itself? It's just like how long it took to write that specific feature. Regardless, all of those arguments were made. The courts will allow it for now until it gets overturned and figured out. But
So let's go back to your popcorn chicken example for a
Yeah.
second. I'm curious, if I have a popcorn chicken business and I decide to sell that business,
yeah,
and I guess everything that goes with that,
right.
can I sell chicken in another form or have it even open another popcorn chicken business at some point down the line? How does that work?
So there's the inventor, and then there's the assignee who's the owner, right? So if you're the inventor and you don't work for a company and it hasn't been assigned to them, then you're by default the assignee, you own it. Once you actually assign your patent to a business, then they're the one who actually owns the patent itself. So once you sell the business, you would have to have the people you were selling it to give you a non-exclusive license back in order for you to also use it at still.
Okay.
And so that's kind of where that happens, is that you can get an exclusive license, right? You can exclusively license it to someone and allow them to use it instead of selling it. Or you can do a non-exclusive license where you allow us to sell, you can license it to multiple parties. But if you sell it, you can't use it unless you get a license back to yourself.
Thank you.
Yeah. So because of this, file a provisional patent that allows you to sell before having to worry about it, right? So if you want to commercialize something and you have the ability to file a provisional patent, then it gives you the ability to say it's patent pending. It gives you the ability to test it out in the fields, and then you don't have this opportunity to potentially not be able to patent it later on down the road. A lot of people come in from a small business perspective saying like, hey, I've got this thing, I've been selling it for 2 years, it's great, here's the feature, it's new, and the reason why it sells is because it's novel and I want to patent it. It's like, well, if you've sold it for 2 years, you can't patent this that you're selling, but if you do an improvement on what's here, you can patent it with the improvement, but the novel feature is the improvement part. Step 7, seek legal advice, or earlier if needed. In general. It's just kind of things you can do before doing it to save some money from a small business perspective, or any perspective effectively. But
How much do you need to expect to pay in step 7?
it depends on like who you're hiring and where they're from. I'm not aware of any like patent attorneys in the Peoria area. And when you look at patent attorneys, we have IP attorneys that usually concentrate more on trademark, right, and more on copyright, and they're great from that perspective. From a patent perspective, you're writing those crazy documents, right? It's called patent prosecution. So like you have to know somebody who can help you write that, or you can write it yourself. But if you don't write it right, then maybe you spend a bunch of money on a patent that's not, well, less money. But if it's not effective, right, then it's a waste. But I would say that, so from a patent perspective, if you're getting industry specific people that have worked in the industry and they went back and they became patent attorneys and work in a large city, you're going to pay, hundreds of dollars an hour, at least $500 an hour probably, if not more. And then locally, it's cheaper than that, but you're looking at, it depends on what type of service you're providing, right? So if the patent is on popcorn chicken, it's different than if it's on like a medical device or a pharmaceutical drug or something that's longer and has a lot of prior art and has a lot of describing and all that sort of thing. If you are doing these steps beforehand and can assist them in finding the specific thing you want to do, it's going to cost less money, right? Because they're going to be spending less time doing more prior art searches and doing more consultation of the different ways in which you can look at it. So it really just kind of depends on where that falls in. So it's vague. It depends. You call them, they'll give you a free consultation usually and give you an idea of what it should come out at.
Do you, in the Brave Launch Accelerator, do you talk about patents and things of that nature in that programming?
Not usually,
Okay.
not in its previous form. Eric and I are working on doing kind of a revamp of what that looks like. We talk about it in a general context, but most of what we're looking at there is like the business model itself, where if a product or company is specific to that model, then we would talk about it more than if it's not. So for example, if the company itself has an idea that they want to then license and sell and that's the customer, then it would be, right? Mm-hmm. It's different than just protecting the idea that's there to then commercialize.
Sure.
And the reason for that is at the spot of where they're at, most of the advice there is get a provisional patent and concentrate on all this stuff and get that figured out and then figure out the patent.
Don't spend all that money there.
Don't spend all the money and stop what you're trying to do here to try to figure out what your patent stuff is. Gotcha. Just get the provisional and not worry about it and then worry about your main
Come see me later.
Yeah.
Gotcha.
Yeah, because a great deal of your risk there is that the time that you waste in trying to achieve the proof of your patent is time that you were not developing, marketing, determining your channel, understanding what the value proposition is to your customer segments. It's all the things that go into developing a value that the market is indicating. That is your better evidence of the value of anything, because you are already commercializing, versus spending all that time saying, this is my precious. Nobody must have my precious. Right? You're better off to say, okay, like Mike's indicating, file a provisional if you think that there is something novel about that, and then, beat the doors down to determine and improve the perception of the marketability and the value and what it can be sold for, and then determine what channels it can be sold into in order to magnify that.
Mm-hmm. I see why you guys are so brilliant. Thank you.
Sure.
He adds the color. So that's what I have. I'm doing a presentation with him in April. We haven't solidified a date yet on similar things, but also the business side of what that is. Overall, these are kind of what I'm bringing today, but I'm happy to talk about more stuff separately or show you the free patent searches and do models of that and what that looks like, but I wanted to open up to questions.
When is it not ideal to look into patents or any sort of IP protection?
When it makes sense to be a trade secret, right? I mean, it's effectively, that's how you protect it in that way. Customer lists, right? Those sorts of things. A lot of times, if you're in an industry like food service, you're gonna be more concentrated on trademarks, right? And brand and what that looks like. And even if you're not trademarking and brand, your one trademark being your name of your restaurant, right? Or whatever is going to be what you're increasing value to from an IP perspective. So when it's not a good idea to actually pursue IP protection is if you do the prior art searches and you see somebody's already invented it. Then you have a couple options. You can either try to license it from them, right? Get a non-exclusive license and figure what that is. Figure out a design around to make your product different, right? And if it is different, then go with that and move forward. Sometimes you'll find that it's already been invented, it's in prior art, but the prior art's 20 years old, and so you can't be sued for it, right? All the patents are expired. And then you just need to then develop a business from getting that going, and then it gets back to brand again, right? Trade secrets on actually making whatever used to be patentable, not patentable now. You just move forward with what you've got.
So I want to go along the lines of one-off creative works,
Okay.
like Mona Lisa, Van Gogh. Like, how do you protect that?
It doesn't become harder, right? You submitted to the Copyright Office, you have the copyright on it. You then promote it in the way that it becomes what the value is, but nobody can then infringe on the copyright. But that copyright now has increased in value, and like you've said, but it doesn't mean you have to pay more for it, right?
Okay.
So like what you've created has increased in value from all of the other stuff, and all you did was just add that one level of protection you needed to in the beginning. And now all of a sudden that copyright is very valuable.
I'm just thinking from, creatives perspective of
Yeah.
like they create one-offs and they're probably not going to create the same thing again for somebody else. How does that increase in value? Could be art, could be whatever. Jewelry, yeah, right? Because you're doing that.
Yeah.
So like,
Yeah.
so then I guess my question is, in Kayla's case, is IP protection even required?
So it isn't. It's not required. It's never
I
required.
mean, not required, but like helpful in terms of the growth of your business, right?
Yeah.
It depends on what the goal is. So if you're making something that you then are reproducing a lot, which is different than what you said, then you would want to copyright on it because it's more likely to then get the attention of a larger jewelry producer to then copy it and sell a bunch of them, right?
Okay.
And then you could actually protect that from a copyright perspective. If you're doing more individual works, and you're not promoting them online or in a bigger fashion, or you're not selling them to celebrities or that sort of thing, if the risk of somebody else copying it is low, then it probably makes sense to just not worry about paying the fees. But if you are actually promoting it, you could like hit on a lottery ticket in a sense, right? I mean, like if effectively somebody actually makes something, and it usually happens more with trademarks than it does with copyrights, but if all of a sudden somebody who's larger makes a bunch of sales on something and actually infringes on your IP, you now actually have the ability to receive income from the IP that it was your original thought, right? But they're the ones that actually were able to get a greater reach, but you get a portion of that greater reach in a lawsuit later on.
Only if you sue.
Only if you sue. But you can actually send a letter and sue and then just hope get a license too, because they don't want to deal with it. Here's a settlement. There's a whole industry of what they call patent trolls, right? Who sue people for $50,000, $150,000, $250,000 settlements really early on, because companies are going to spend millions of dollars for a patent lawsuit. It's an extortion scheme and it's ridiculous, but it happens.
I'm just curious, this might be going off too much of a rabbit trail, but like nowadays we see all sorts of Bob Ross merchandise, the painter guy. Like how does that work? I mean, he passed away like two decades ago or so. So is his likeness like branded by his company, or how does that?
His likeness would be owned by whoever went into the will, right? It could be a company, it could be family, it could be whoever, right? And then they now have the ability to control the rights of that likeness if they have the rights to the likeness, if it's been filed.
So it sounds like one company or one family would have the rights to it. If anybody outside of those parameters use it, they would be violating it. Is that right?
Mm-hmm.
Okay. Just curious.
But more likely than not, they just were allowing and doing more non-exclusive licenses, right?
Yeah.
Than he probably would have when he was alive, because he could show up and do the things or control that or whatever.
What about, on another note, what about like international, like, I don't know, different countries overseas, like taking
That's a good
stuff? I mean, do you go after that, or are the rules different, or how does that?
The rules are very different, and that's a good point. I should have brought it up. From a patent perspective, your U.S. patent covers the U.S., right? You can get international patents, and you would have to pay separately for those international patents that give you coverage in those different countries or the European Union or different areas. To be infringing a U.S. patent, it has to touch the U.S. in some way. So if it's an international company that's infringed and they're selling goods into the US, you can sue them for infringement for the products that make it to the US as US sales. You can also sue for if they're manufacturing in the US and selling overseas. Everything manufactured in the US is also infringement. But if you have a company in France who's manufacturing in France and selling in France, they don't infringe your US patent because it's only giving you US rights. From a trademark perspective and all that sort of thing, I think it's similar, but I don't have as much familiarity of how those rules work. And back to patents and weird, strange things, they were then trying to figure out, does a sale occur at the location of where an agreement is signed, which seems to still be a gray area. So like, if you're selling, so if you're manufacturing in the US and you sell everywhere, then all of the things manufactured in the US are infringing. If you manufacture overseas and sell into the US and everywhere else, then usually only the things that come into the US are infringing. But if the people that agreed to that contract or a contract that allows for sale of their supplier or distributor or whatever, if there is an agreement that allowed for those sales internationally that happened in the US, is that enough to then say that you actually have US territory on the rest of those sales? You know,
You bring up a good point. So now with the advent of all digital signing, how do you deal with jurisdiction?
Right.
Especially more so now with regards to non-fungible tokens, metaverse, and all the crazy new technologies. How do you?
For a while, they talked about server location. If there's a server in the US that it touches. So I don't know where it's at now, but that was one thing that they looked at.
That's interesting. Huh. Coming back to the NFTs and metaverse and virtual reality, are those things patentable or is there IP protection?
Taking something in the physical world to virtual reality world
Yeah.
wouldn't be novel enough, right? It has to be like an additional thing. But like, there are areas that are patentable, and then it gets into like, they have been having recent decisions that in the US, artificial intelligence can't be an inventor and can't be the owner or author of a creative work. So you can't actually have a computer program create a design and then copyright that and have it be the AI's copyright. So that's interesting. Other countries allow for artificial intelligence to be patent owners.
Interesting.
I just want to speak on what you
Yeah.
said. So, like NFTs, non-fungible tokens, how it works is like it's secured through a blockchain. So when people try to fish at it, hack it, try to steal the actual design, it's no good. Now people do like mint, like they try to copy the actual original, mint it and sell it. But individuals who are knowledgeable, they understand the difference. But some people unfortunately do get scammed.
So use the art behind you as an example. Tonight I take a picture of that art piece, put it on whatever the NFT site is, sell that for $1 million. How would the artist know? I don't even know who the artist is.
Oh, it's a reproduction.
First,
What's that?
they probably did it already. But
Well,
They should have.
but that's the assumption, right? Like but we don't know.
No, that's
Right.
why a bunch
Well-
of people are getting like screwed over because like a bunch of artists who like post their art on Twitter and everything are just like people are just going and reposting their art on whatever the site may be that they're doing that, and
It would still be infringement. What you're getting into is how do you actually track that, of who you actually sue, and what's the collection, and all that sort of thing.
If you can even collect.
Right. But you don't have to do additional copyrights on that work now created digitally because it was already on that work. That would be a reproduction.
Right. But if you don't even know, like, somebody sold it and put it up there, like, you would never know.
Right. Well, you might, right? If it becomes news or whatever, this, that, and the other thing.
For $1 million, yeah, you're probably.
So maybe this is a new startup. So maybe this is a new startup idea, right? Like, go like be the curator for all the artists, just like the guy that was doing.
My art.
Yeah. You touched on one thing too about when do you want a patent or not, or is it worth it, and that sort of thing. And kind of goes back to your question of whether we talk about intellectual property a lot in Brave Launch that we did. There are so many people that get a patent, but either don't have an intention to actually create a company on that idea, because it's a very different thing to create an idea and protect the idea and come up with an idea versus creating a company that does that idea, right? And once you have the idea and you have a patent on it, it's really hard to find somebody else to create a business off of it, right? So there's very few people that are entrepreneurs that are like, I want to be an entrepreneur, but I don't have an idea that I want to do myself. Does somebody have an idea to give me that I can create a company off of? Or you then are trying to sell it to a company that's already in the industry doing their own thing. So it has to be valuable enough for them to stop what they're doing and create this new other thing or add the feature. Usually what happens is they try to get an exclusive license for as little as possible to then maybe put it on the shelf, right? And decide if they want to do it later or not, but they know nobody else can use it if they have an exclusive license. So there's a lot of people that then go down that route. They think they have this great license. They think, such and such manufacturing company is going to then create their product. It's so much better than what they sell currently. They've had great discussions about it. They give them an exclusive license because they could get a little more money if it was exclusive versus non-exclusive. And then they keep on calling the company after the license agreement because they're not getting royalties from sales because they're not making sales because they never manufactured it.
Yeah.
So like if you have an idea that you want to patent, but you don't have any plan to make a company off of it, it's just a lot harder road to then find a way to commercialize it to get value from that patent. So unless you have the Steakums guy or something.
Obviously, of course, you look at YouTube, which is having a lot of copyright challenges lately. How far along, in your opinion, how far along are we in terms of addressing that? I mean, even blockchain, NFT, and all that stuff. How far along are we in terms of the United States government in terms of providing protections for content creators online?
I don't think very far, and I think that's why they're going after like the private companies to try to incentivize them from a public good perspective. I know we had a case where actually we had a room full of 6 or 8 people. We had interns at the time, which was also great, whose job for like a month, I think, was watching YouTube videos and logging the videos of a multi-level marketing company that had all of these people that sold products and did videos on YouTube using people's songs or images or whatever. And so then the multi-level marketing company then got sued from one of the larger music firms to be like, hey, you're using all of these songs, you owe us X amount of damages. So they actually had to show how often it was used and who was used and when. And so they had to hire a company and pay a company to then go through that, right? If YouTube did it already for them, they wouldn't have to spend the money.
Right.
I watch a lot of podcasts, and like the leader, like it's like over, I'd say 300 podcasts that have started since 2020, I think. And Joe Budden, I know a lot of people don't like Joe Budden, but what Joe Budden did, he started a podcast revolution, I say. And they used to have something, they had a segment called Sleepers, and they would just play music at the end, just probably like 10, 15 songs or whatever. And he went from a deal with Spotify to just being independent, and they had to, like, they were real close with artists, so they had to go through everything, just like you said, and they had to pinpoint exactly when songs were being played and stuff like that. Like now what they do is, like, they just play like mixes, like a random DJ mix, so people can't recognize the record. So
Yeah, no, I mean, it's crazy. And from a Spotify perspective, it becomes more important for them, right? Because they're also selling music, right? So once they get into podcasts that are then potentially infringing on those music rights, they're trying to figure out, okay, where do we balance this? How does that work? And so once they documented what was being played when, they could then pay royalties on those to people they needed to from a Spotify perspective. But without that, they couldn't figure it out. So it's probably the agreement they signed. It's like, we'll pay you to get your podcast, but we can't then also pay the royalties on top of that to all the songs that you're playing. So are there a way we can do this to still be able to provide what you've normally provided, but without having to get the full rights to the songs?
In a like a world of like rapid prototyping where people can basically make a lot of stuff like in their own homes. Like we have a lot of people who are able to just create what they see like with a digital caliber and a 3D printer, recreate it. What is the usefulness of a patent if it's so easily destroyed? Because you could go through a process and say, we did X, Y, and Z in order to create this product, and a 14-year-old goes, well, I was able to use my digital calibers and 3D print it, so now it's no longer, it's a completely different process that I made it.
So the product itself would still infringe, right? So like if they'd use a different method to get there, is that what you're saying? Like they wouldn't infringe the method because now you can use a 3D printer and kind of get there, but it's still not the same method that was used from a manufacturing perspective.
Right.
And then the product, if it still actually infringes the claims of a utility patent, then it would still infringe. But nobody's really worried about the home 3D printer, right? They're worried about mass production and mass sales and
Right.
mass loss.
But I mean, at that point, from a small business perspective, if somebody is able to redo your thing, what's the usefulness of a patent in that? Because now your design's completely out on the web, and anybody can download it and do whatever they want.
Oh, well, the patent itself is already public disclosure, right? So part of that process is also deciding and knowing that what you have a patent on, everybody knows how you did it and how they can do it now.
Sure.
It's just that if they do it, they're infringing. And so from a trade secrets perspective, that becomes harder from that perspective. If you want to keep your design and what's in there and all that sort of stuff as a trade secret, it's really hard because there's just companies out there who just break stuff down, right? And then they sell the information of what was broken down. Or they do that as a service for somebody, or they do it to create their own. And so that's kind of where the patents actually do come in, is because if you do a breakdown service, you create a new way of doing it. So you still have a patent on that product. So if you sell the product, it's still infringing.
So when it comes down to it, though, like you still have your thing potentially out there, and you may have a patent against it. Does it really just come down to you provide a better service? Because like they're still able to do it. They're like, there's no way you can go after everybody with a 3D printer and be able to do it. So would it be better to do something like an open source common Creative Commons where you're able to work with people, or is a patent still the better way?
It's industry specific, right?
Sure.
So like if what you're talking about is something that you can then 3D print and get all of the ability of what normally was presented, then maybe that is the case, right? If the people know that, well, I'm not gonna pay for it because I'll just then create my own, right? There's kind of it depends on the pricing and how big it is and how wide that market is of people then recreating it from the 3D printer, but you still get that protection of if somebody is now creating it and selling it on their own, you can then still cause them to stop doing that. But if it is a cheaper, smaller thing that everybody would just like to 3D print, right, you have that option to do it from a public domain perspective. You just then have no way to actually monetize that back unless you're getting advertisement or something strange.
Sure.
Right? So
if you were considering that, as one of the potential risks of your business model, what you might consider instead is to actually create the pattern and sell the pattern to people that are using 3D printers to produce that product on their own, but with a licensed actual pattern from the design that you created as that novel item.
And I know that OSF created a product that was some sort of whiteboard thing that you could do in the waiting room that gave people something interesting to do that you could 3D print, and then started giving those 3D print instructions to different hospitals to print those to like have that in the waiting room, right? So those are the areas in which that can occur. So maybe it's the method and source code of what protecting that if you're trying to sell it, right? And then selling the instructions and what that looks like and the designs and what that looks like. But
Yeah, RCL River City Labs was a part of that.
yeah,
And it was open sourced.
yeah,
So
right. Yeah, exactly. That was probably to go with that, right? It's completely different.
Yeah.
They're not looking to monetize that in the way that you would other things from a small business perspective.
Yeah.
Well, Mike, thanks so much for your time.
Yeah, no worries. Thank you.
All right, so we're gonna close for tonight.
Oh, there's a chat.
Yeah.
Oh.